Today, San Francisco values become America's values.
Marriage matters. Family matters. And that's what we're affirming today.
A huge celebration at San Francisco City Hall after an historic U.S. Supreme Court decision. Good evening. Welcome to KQED Newsroom. I'm Scott Shafer. Today, the High Court ruled that same-sex couples have a fundamental right to marry. No longer may this liberty be denied to them. That's what Justice Anthony Kennedy wrote in the landmark decision. Kennedy was the swing vote in the 5-4 ruling. Joining me now to discuss this precedent-setting decision are Professor Rory Little from UC Hastings College of the Law and Kate Kendell, Executive Director of the National Center for Lesbian Rights. Big day today in the United States, folks. I want to ask you first, Kate, what was your reaction when you first heard this decision come down?
Oh, I burst into tears, and I'm not the least bit ashamed of it. It felt like not only the culmination of so much work and effort and sacrifice by really countless people, but it also felt like it was the harbinger of a new chapter where maybe more freedom, more justice. It felt like, you know, those words, equal justice under law, inscribed on the Supreme Court building. It felt like we were now, that meant something for all of us.
It was more real. Rory Little, talk about the ruling itself. What are the legal underpinnings of it?
Well, this is both on due process grounds and equal protection grounds, which is a very important point, that this is solidly based on two different strong constitutional doctrines. And the idea is you have a substantive due process right to marry, and you can't discriminate on a factor which has no rationality, as well as you can't discriminate between people. And Justice Kennedy's signature line is going to be equal dignity in the eyes of the law.
There were some very vociferous dissents as well. Chief Justice John Roberts saying you can support same-sex marriage, that's fine, celebrate this decision, but it's not in the Constitution. Some thought he would go with the majority to be on the right side of history. What do you make of the fact that he wasn't, either one of you?
Well, I mean, obviously Professor Little can probably really speak to this in a more nuanced way, but for me, it felt like it's going to tarnish his legacy. He will be on the court still as Chief Justice at a point when we look back as Americans and as historians and as legal scholars and say, boy, we got it right. And the dissents, not only did the dissents not give ample justice and a sense of dignity to LGBT people, but I felt like they were openly insulting of Kennedy's view and the majority's view that the Constitution is expansive, it moves with the times, and times can't blind people to injustice.
And Rory, there was even the phrase, a threat to democracy from Scalia, where he's kind of known for bombastic dissents, but were you surprised at the tone at all?
I actually was surprised at Justice Scalia's tone, because it's got to be one of the most personalized, vehement dissents. He's actually insulting to Justice Kennedy on a style. He says the style here and insults him. That's surprising even for Justice Scalia. And you know, the argument that it's not in the Constitution, that's just kind of a tired argument. It's right. There's nothing in the Constitution about same-sex marriage. There's nothing in the Constitution about almost anything. I always tell my students the Air Force is unconstitutional because there's nothing in there about the Air Force.
Was this a decision, Kate? You know, there can be narrow decisions and broad decisions. Where would you place this one?
Oh, I think it's expansive. I agree with Professor Little that the underpinnings are broad, using both the Equal Protection and Due Process Clause of the 14th Amendment. But also, Kennedy, I mean, he essentially puts forward 4 justifications for the ruling. And not only is there legal doctrinal support, but really just what kind of country are we? And this 4th point talks about how the children of same-sex couples are stigmatized by not having these relationships recognized. That sort of language, how it's dehumanizing to not be included in this very sacred and important right, how it hurts children in addition to the parents. That sort of language, I think, will be enormously important in just affirming to all LGBT people, not just that the law protects you, but that you matter as a citizen.
Rory, I was talking today with some folks from the National Organization for Marriage. They oppose same-sex same-sex marriage. They're talking about a constitutional amendment to try to get this changed. Is there anything that you see, legally or otherwise, for them to hold on to grab onto?
Well, there isn't anything in this opinion. This opinion is very unambiguous, very clear. There's no separate opinions in that 5-justice majority. They all agree with what Justice Kennedy wrote. And, you know, Justice Kennedy says, some opponents say this disrespects marriage. He says that's exactly backwards. This shows the respect for marriage that same-sex couples have. They would like to be part of the institution because they respect it. So I don't see any litigation design. You know, after Brown versus Board of Education, there was a lot of fighting about what does it mean. I think on this one, it's absolutely clear. I think Kate's right on that. You know,
Prop 8 from California was before the court a couple years ago, and the attorneys opposing Prop 8 at that time said there's a fundamental right to marriage. And they chose not to go there, the Supreme Court. Instead, they kicked it back on sort of legal technicality that the proponents didn't have legal standing to bring the appeal. Why do you think, like, what's changed? Why are they now saying, yes, there is a fundamental right to marriage and you have to afford that opportunity to everybody?
I don't think anybody would have disagreed even then that there was a fundamental right to marriage, although the standing argument on Prop 8 was designed to, I think, allow strategically the country to come up to speed. You know, since Prop 8, state after state and circuit after circuit has said, and the Windsor case, which was decided with it. The DOMA case,
striking down part of DOMA.
You know, at this point, the court is not ahead of the curve. At this point, the court is endorsing what most jurisdictions and people have already endorsed.
I was just going to say, I completely agree with that. And what's interesting is, just in the 2 years since DOMA, the central core of DOMA was struck down and Prop 8 died, even though it was on a technicality, not only have we seen a sea change in the number of states that now permit same-sex couples to marry, now at 37, but the polls show that over 60% of our friends, neighbors, coworkers, fellow citizens support the freedom to marry. And Kennedy is no real firebrand. He is judicious, he is cautious, and I think he needed those 2 years. I agree. I think he always believed that there was a fundamental right to marry, but would he have gone out on a limb to find that in the text of the Constitution 2 years ago? I'm not sure. This extra 2 years gave him the time with the other 4 to now say, let's do this.
You know, another person who has evolved on this famously is President Obama, and he came into office saying he opposed gay marriage, and now he is leading the charge on it. What do you make, either one of you, about what influence has he had either on the public opinion side or on the courts? I mean, the federal government came out in several of these cases in support of same-sex marriage before the court.
You know, the biggest influence really that this president has had, and he did not always endorse same-sex marriage when he was running for office originally, is when he decided not to defend the Defense of Marriage Act, and the Solicitor General went into court and said, we're not going to defend it. That was a big turning point in a lot of federal courts' views.
Why does that matter so much?
Well, it matters because the administration has a great force on these constitutional issues, both at the circuit level and in the Supreme Court. And when they said, we can't defend this discrimination in DOMA, that was a big signal to lawyers that there was a legitimate view, a mainstream, if you want, view. And the Solicitor General was severely criticized. Don Varelli, at his confirmation hearing, was excoriated for not defending DOMA.
Yeah.
Well, and it was a shift, because up to that point, Obama had said, I think it's unconstitutional, but my job as the executive branch is to defend it. So it was a shift to change that. I think that was a huge moment. And then when he made the statement in the run-up to the 2012 election that he had evolved and supported the right of same-sex couples to marry, I think that had everything to do with the fact that for the first time we won 4 measures at the ballot box. I think the president really led and people followed.
Talk about the timing of this decision. You know, we knew it was going to come at the end of June. We thought it might come yesterday or Monday, and then they added Friday. And of course, this is Gay Pride weekend in San Francisco, and people were saying, oh, I think they're going to do it Friday because it'll make for a great celebration. Do justices at the Supreme Court think about things like that?
I think they know. I think they know. They have clerks who know. I mean, they're not completely cloistered. And I think, you know, there's also some symmetry, because every key ruling in Kennedy's legacy supporting the dignity of LGBT people has come down on June 26th. So I wouldn't be surprised
what do you
if
think,
there
Rory?
was some poetry to this.
You know, I think Justice Kennedy knew exactly what was going on in terms of the anniversary of the Windsor and the Doma case, the anniversary of Lawrence in Texas. I think he knew. And I said this morning on a different station, I said, you know, if they lived in San Francisco, they would do it today because Gay Pride is this weekend.
Yeah.
And I guess Justice Kennedy had some influence on that.
So where does this, what does this say, this ruling on Friday, and then also the decision upholding the Affordable Care Act subsidies written by Chief Justice Roberts, a 6-3 decision. What does it say about where the court is? Is it moving to the left?
Well, I think this term is going to be viewed as moving to the left, and we'll see what they do. There's an EPA case up for decision still on Monday. If the administration wins that, that'll be sort of 4 wins in a row, and it'll show a shift. I actually think it shows the influence of Justices Kagan and Sotomayor, who were silent today, but I think have really influenced the content of what the dialogue is there.
How? How does that work?
Well, because they're both pushing from the left in a very vigorous way, and they're very different people. Kagan is a high-ranking, you know, Harvard, law professor. Justice Sotomayor is kind of from the streets in some sense. And when they're in there fighting, I think the rest of the court hears that.
Before the decision came out, Kate, a lot of people in the LGBT rights movement were saying, well, you know, once we get marriage, we're done. What do you say to that argument?
I think people know that's not true. I mean, I think it's almost offensive to make an argument like that. I understand that marriage is an important headline, and boy, we needed this high water mark, I think, to do some of our other work, because as long as the government is in the business of discrimination, no one checks their own private prejudice, but we still have private prejudice. We still have assaults and murders of transgender women. We still have homeless youth that are way overrepresented in terms of the LGBT population. We still could get married on Sunday and fired on Monday in most states. There is a huge amount of work yet to do, but what we have to do is let's harness this momentum. We have now, because so many people came together, been given a tremendous once-in-a-movement opportunity to push the lever of justice even farther forward.
Is there anything either in this ruling, Rory, or recent decisions, Doma, Lawrence, and so on, that might help folks who get fired because they're gay?
I just think there's no doubt that this ruling is going to increase the protection in other areas, because the recognition of equal dignity in the eyes of the law is not limited to just marriage. It's going to be extended. The due process right is subject to the highest level of legal scrutiny under the Due Process Clause. They didn't say a level of scrutiny for the Equal Protection Clause, but they've got to give it that same strict scrutiny. So I really think this puts it up on the level. There's no intermediate discussion here. So I think you're going to see housing discrimination, job discrimination, other discriminations. They're going to be more strongly protective in every circuit, including the circuits that so far have been dragging their feet, because they were dragging their feet in this one, and they got, in a sense, their baskets handed back to them.
And then, Kate, just quickly, do you think that this will renew the push in Congress for end of the Employment Non-Discrimination Act?
I think it will certainly move a conversation in Congress. And actually what we're pursuing now is a broader bill. We're pursuing now a bill in Congress for employment, housing, and public accommodations. And I think we're going to have some momentum for that. And regardless of whether Congress acts, I think we have to do everything we can in the states to move issues forward.
And then we've got a presidential election next year where I'm sure some of these things will be discussed. Kate Kendell, National Center for Lesbian Rights, Rory Little from Hastings College of the Law. Thank you both very much.
Thank you.
Pleasure.
Definitely a big day today across the country. Hello, I'm Thuy Vu. For many months now, the nation has also been engaged in a discussion about race and the criminal justice system. Specifically, are people of color treated fairly under the law? A report released this week shows that African Americans are disproportionately represented in San Francisco's courts and jails. Among the report's findings, while black adults represent only 6% of the population, they represent 40% of the people arrested. Joining me now to discuss those findings are two key players in San Francisco's criminal justice system: Sheriff Ross Mirkarimi, who oversees the county jail system, and Public Defender Jeff Adachi. Welcome to you both.
Thanks for having us.
You are both co-chairs of the San Francisco Reentry Council, which commissioned this study. To what extent were you aware of these racial disparities in the system before the study? Jeff?
Well, I've been a public defender for almost 30 years, so I see it every day. You see in courts primarily black and brown people being brought out of the holding cell. So what this report did, though, is really confirm the numbers, the hard numbers that show that at every stage in our criminal justice system, African Americans in particular, not only 6% of the population, like you mentioned, but 40 to 45% of the jail population, of the people arrested. And the report also found that even though African Americans are more likely to meet the criteria to be released from jail pending their trial, they're less likely to get out. And that's a shocking statistic.
And Sheriff Mirkarimi, what do you make of all this? Why do you think these racial disparities exist?
Well, I think they have for decades. I think the report is a real affirmation of reality that I think many of us have known about and have really been urging other arms of, I think, local government, getting noticed by the state government to make some significant change. I don't think that this is anything dissimilar from other cities around the United States. But what I think it does is it's a bit of an indictment, I think, on San Francisco's liberal sort of reputation, forward-thinking, progressive reputation, that maybe we're not just all that, and maybe we're overlooking some key variables that enable this behavior to happen. So
do you think the city has become complacent because of its reputation for diversity, and what are the variables that you are talking about?
Well, I mean, we do, and I'm proud as a public official, a citizen of San Francisco, to celebrate our racial diversity, but I think that really what's at risk is our class diversity in San Francisco, and that translates into the criminal justice system. We've seen that, I think, uninterrupted for quite some time, but it's really on hyperpath right now, and I think this report comes at a good time. I think it compels us to answer the report, and I think that's where the real test is. I want to see the leadership and the people come together and say that we're going to commit to some meaningful change.
In his response to the study, Police Chief Greg Suhr said his officers, quote, do not disproportionately target black people, but that they're often sent to neighborhoods that have high African American populations where crimes exist. What do you think of his response?
Well, first of all, if you look at the most basic sort of police contact that you have, other than saying hello to an officer, it's a traffic stop. And African Americans are 4 times as likely to be stopped for traffic offenses. Does that mean because they're worse drivers? No, they're just being stopped more often. And many arrests stem from that. It's just, you have this initial contact. It is a contact that is based often on a police officer's perception of a person. And all the studies have showed that police officers are not immune to what's called implied bias, which is the biases that we all hold within ourselves that we're not even aware of. So these judgment calls are made. You do have racial profiling that goes on. There are charging decisions that police officers make as to what to charge somebody with. At every stage, it shows that these biases infect decision making. And so this is what we're trying to address, through the reforms that we've suggested.
So what are some of the reforms you can put in place to address implicit bias?
Well, one thing is training. The studies have shown that once a person is better educated and informed on your bias, and there's actually a test that you can take that was developed by Harvard called implicit association test, where you can test your level of bias, that people tend to correct for those biases. So that's one thing that could happen. The other thing that we're doing is there's legislation now that is going to require the police department to report on all of the contacts that they have with citizens, and also the gender and race. We're not doing that now. And so I think once we become more aware of it, we can then begin tracking it and then holding officers accountable. We had the racist text scandal here in San Francisco. That was an example of explicit bias. And so we need to root out those officers and make sure that we do a better job of vetting officers who hold those kinds of views, and have officers who have a stake in the community, who are more connected with the people that they're policing.
And it's not just the police departments, the sheriff's department too, that is actually the point of the legislation. And we are the second largest law enforcement agency in the city, and I believe that we have to be held to that level of accountability and transparency that I just don't think has been really divulged yet in a systematic way.
What are you doing in your department to address implicit bias?
Well, I mean, we do a fair amount, because we're the ones who really try to divert people out with the approval of the courts so that they do not have to be incarcerated. We fund 95% of the city's pretrial program. We're trying to really help create a different pathway so that the reflex is not just incarcerate, but hopefully keep people diverted from the system. In fact, we're making national, sort of national history in doing this, but we still have a far way to go.
Jeff, I want to go back to the point that you brought up earlier, those racist and homophobic text messages. It was revealed that 14 San Francisco police officers exchanged them. In that, and in addition to the problems at the police DNA lab, as a result, you, along with the district attorney's office, are now investigating, reviewing 3,000 cases. What is the status of that review, and how many of those cases are you having to throw out?
Well, any case involving these officers is now questionable, because when you talk about an officer's credibility, if there's evidence that they've engaged in this case, I mean, this hateful language against people of color, that has to be questioned. And so those cases are being reviewed. There's already been about a dozen cases dismissed, and it's going to take until the end of the year. So we have a lot of work to do. But beyond that, we're looking at how bias affects other parts of the system. Judges, prosecutors, even defense attorneys. I mean, one of the things that we're doing is training our lawyers on bias, because if you hold a bias as a defense attorney or a prosecutor, that's going to affect the way that you treat a case. And again, the studies have shown consistently that when you have an African American client, that client is more likely going to be convicted, going to receive a poor disposition, and is more likely to be sentenced to prison.
So then how do you train a lawyer about the implicit bias and make sure it doesn't happen?
Because we make assumptions about people. I can see somebody walking across the street and I have a certain reaction to that based on how they look. And the same thing happens in court. So making people aware of it and also looking at outcomes. Like, for example, I recently handled a case where I had a young African American client charged with gun possession, and he was charged as a felony. There was a white individual who was charged with the same crime, same background, no criminal history, and he was charged as a misdemeanor. So I brought that to the district attorney, and they ended up, changing their charging decision. How did that decision get made? Who made that decision and why? And that's really what we need to get to.
Right. Ross, did you want to add something to that?
Well, I mean, really, this should not be a siloed sort of work in progress. I mean, it really, the report and the discussion, I think, requires us collectively in the criminal justice partner to come together, to really advance this change and deliver results. The fact that Jeff had to advocate for the disparity between two cases to the judge in itself is a reflection that there is nothing systematic about how we can really make that wholesale change. And those are the recommendations that I think that we're putting forward. Better data makes us more accountable. That's what's significant about this report. But there really does need to be some common agreement with the courts, district attorney, public defender, the rest of us, that we're going to make, I think, that commitment of making sure people are not disadvantaged with the criminal justice system.
Let's talk about your department now specifically. You're dealing with your own scandal. Inmates say they were forced by sheriff's deputies to fight for entertainment. Was racial bias at play in these fights?
I couldn't tell you if racial bias is at play, but
I could.
Yeah,
I think it was, because all the inmates were of color, and the deputies, at least the main deputy who was involved with this, was white, and he had a history of sexual assault, of harassing in particular inmates of color, and it was extremely, I think, outrageous that he was allowed to remain on the job, even though the city ended up settling a case, after, they basically admitted that he had sexually assaulted an inmate. So, these are the systematic problems I think that we need to address. When we have bad players, whether it's a police officer or sheriff, whoever, we need to deal with that.
So here we have the sheriff, you're the guy in charge.
I completely agree with that.
What are you doing about it now?
Well, immediately when I learned of these incidences, I called out that there's going to be immediate investigation, not just from local authorities, but I called in the feds, the FBI, and they had accepted our request. And so there is a criminal investigation underway right now. And I'd already set out an internal investigation that resulted in the notice of termination for one deputy, and others that had been implicated are also under investigation. And disciplinary hearing as well too. So we pounced on it, and it's rare for a local, I think, sheriff or law enforcement official to call in the FBI. It's usually FBI are required to come in, and so we extended the invitation. So we pounced on it, and I think it sets exactly the kind of direction we need to go, that we're not going to leave any room to neglect this kind of experience.
And this case has also prompted you to plan to have 30 body cameras worn this summer by your deputies at the county jail. How will those cameras be used, and will the videos be available to the public?
We're working on policy by inventing one that hasn't ever existed before in California. We would be the first county jail system to actually deploy body cameras. No prisons and jails really do that, or not very many around the United States. The call has been for law enforcement on the streets to wear them. I think that's an incomplete call. It should also extend to law enforcement that works inside prisons and jails. Through the spare change and staff savings that we were able to unearth, $50,000 only buys us 30 cameras, and I'm piloting that once we're ready in our most dilapidated jail that has had historical problems, I believe. And the data will always be uploaded into a cloud system. But the policy has to reflect, you know, our adjustments for privacy rights that law requires, an adjustment for storage, how long, you know, and we'll work that out.
And just real quickly, you had requested for additional funding from the mayor's office for more body cameras than just 30, and you did not get the funding. What do you think of that?
Well, I think he's playing politics with public safety, quite frankly, and I was overt about that at the Board of Supervisors hearing the Budget Committee, because the police department got over $6 million for body cameras. And again, I think if we're trying to be sensible about improving public safety and trust with law enforcement agencies, then across the board we should be funding our agencies appropriately for these kind of assets.
Okay. All right, we will leave it there. Thank you, gentlemen, both of you, for coming in today.
Thank you.
Public Defender Jeff Adachi and Sheriff Russ Mirkarimi.
Thank you.
And for all of KQED's news coverage, please go to kqednews.org. I'm Thuy Vu. Have a good night.